Here's a quick story that'll change how you think about finders keepers. Welcome to Once Upon a Case, because the law isn't just for lawyers, it's for everyone. It's 1896, England. A water company owns a pool, basically a man-made reservoir. They hire a man named Sharman to clean out the mud at the bottom. He's not treasure hunting. He's doing his job, scooping sludge, and boom, he turns up 2 gold rings buried in the muck. Instant question: who owns the rings? The guy who found them? Or the company that owns the pool? That's South Staffordshire Water Company versus Sharman. Let's hit the facts. The company owns and controls the land and the pool. Sharman's an employee, working under orders to clean it. When he finds the rings, the police briefly take them, but then the company says, "Hey, those are ours." Sharman claims finder's rights. Classic, I found it, so I own it against everyone except the true owner. Now, the holding, the court's decision. The court says the company wins. Why? 2 big reasons. First, possession of land includes possession of things attached to that land and possession of things under that land, even if the owner didn't know they were there. The rings were embedded in the mud at the bottom of the pool, so under the land, not just lying loose on a shop floor. Second, Sharman was working for the landowner, on the landowner's land, doing the landowner's task. In the course of employment, what he finds in that role isn't his to claim. Compare earlier case, Bridges versus Hawksworth. A customer found banknotes in a public shop area and beat the shop owner. There, the finder wasn't the shop's agent, and the notes were just lying around, not embedded. So the occupier's control over the premises, and over what's in or under it, carries weight. So the legal rule you can pocket: if something's attached to the land, if it's under the land, the occupier's right trumps the finder, especially when the finder's on the job. Takeaway? This case shapes modern finder's law. It feeds into decisions like Waverley Borough Council versus Fletcher, where a brooch found buried in a public park went to the council, not the metal detector hobbyist. It influences how workplaces handle lost or buried property, construction sites uncovering artifacts, and how museums sort claims when items come out of the ground. If you're an employee and you discover something while doing your assigned work, chances are it belongs to your employer or the landowner, unless a statute says otherwise. If you're the landowner, control is key. The more clearly you control the land and what's on it, in it, or under it, the stronger your claim. One more nuance: if an item is simply lying on the surface in a public area, and you're not the landowner's agent, finders keepers can still work, until the true owner shows up. But once it's embedded, or you're working for the occupier, Sharman's rule kicks in. So South Staffordshire Water versus Sharman teaches that ownership isn't just about who spots treasure first. It's about control, location, and relationships. Land, depth, duty. Finders might be keepers, but not when the ground itself speaks for the owner. Thank you for watching. If you like this case story, please follow along for more. See you on the next one.